This will be probably a full 2 hours. So we'll take a break about an hour in. Um, and then we'll, take a 5-minute break. But at any time, if you need to take a break, that's fine. You can always just come back. And then we are recording this, and Michelle will send that out later, as well as the slides. I will say the slides are very text heavy, and that's because so later on you can actually, because there's going to be a lot of information in the next 2 hours. So afterwards, you may go, wait a minute, what did she say about this? And you can go back to that slide, that page in the slide deck. I hate presentations where the slide will have like one word on it, like grow, and you're like, well, that's not helpful to me later when I'm trying to remember what was talked about on that slide. So I do tend to be text heavy because we know I send these out to you afterwards. And so we want to make sure you have that information to reference back, plus you'll have the video. So I just want to do some
Sandy,
housekeeping. Oh,
excuse
go
me.
ahead.
May I interrupt? I'm sorry.
Oh,
Um,
absolutely.
you don't even know this. The SCORE Nashville has just gone into partnership with NBIC, Nashville Business Incubation Center, and we will be co-sponsoring our events from now on. Unfortunately, I didn't have time last night to send Sandy the information to put on the slides, but we are very happy to have them and their cohorts with us. So welcome and welcome in
Oh,
the future. Thanks, Sandy.
oh yeah, thank you, Michelle. That's great. And once you get that information, I'll put it on all my slides so we can make sure to mention them going forward. So that's great information. So we're gonna do some housekeeping slides first, and then we'll kind of get into it. Just gonna talk a little bit about SCORE, who we are as an organization, if you're not familiar with us. So there's this SCORE national chapter, which is like over the entire US. And then each there's several different chapters, and we're the Nashville chapter of the overall SCORE organization. We are a nonprofit, so we're all volunteers. I am Michelle. Anyone you can meet with in the SCORE network are volunteers. And so we just want to kind of give back our expertise to small businesses to help them, on their journey to, as they start either wherever they are in their journey, we want to help support those small businesses. We are also a partner with the Small Business Administration, but we are separate from them, but we come alongside them to help kind of bring some mentorship and education are kind of the two pillars that we focus on SCORE. So one of the big things is mentorship, and I don't know if you want to put in the chat if you actually have a SCORE mentor today. Mentors are a fantastic resource. It's a free resource for small businesses. And think of a mentor like your business coach. So they're kind of there to be your sounding board, to ask questions. They're excellent in a broad range of kind of business related issues and experience and expertise. But they will also can bring in subject matter experts. So I'm not a mentor, but I'd be a subject matter expert. So they would bring me in for a deep dive on if somebody needed, to go deeper on a specific question. They also have a, a, a network of subject matter experts they can bring in. Your SCORE mentor is there for the life of your business. So if you need them in the beginning a lot and then you don't need them for a while, but then you need them again when you have another kind of phase in your business, they're kind of there for you, whatever you need. And they're that coach. Again, they're not going to give you answers. They're not going to say you should do this or do that, but they're going to be that sounding board for you to kind of talk through what you're doing. Have you thought about different options and kind of bring different resources to you as a small business owner that you can't, it's just kind of having that support system that you may not already have in your life. They can just add into that as a resource. The other thing that SCORE does is education, both the national and the Nashville chapter. So we offer local workshops like this one here that our chapter puts on. Some are offered every month, some are offered every quarter, some are offered a couple times a year. It just depends on what they are. So Michelle does a great job of kind of listing 2 to 3 months out on the website so you can kind of see what's coming up. And then we also have kind of one-off or maybe once a year or a couple times a year events like our pitch competition is kind of once a year. I'm hearing some background noise, Michelle. I think
Got
somebody
it.
might need to be, okay. Thank you. Um, so then we have very specific kind of workshops that might just be kind of lunch and learns or special events that are happened more infrequently. But again, Michelle puts them all on the website. In addition to what the Nashville chapter does, the national SCORE organization also offers webinars. And so maybe the national chapters is you need a marketing one, and we don't have one coming up in the next month or two, but you may go to the national organization and they may have a webinar coming up about branding or marketing. So check those out as well. And so we want to make sure that you get that kind of education component, whether it's local with us or with the national organization. And you can go down to the website in the bottom left-hand corner is for the Nashville chapter. But you can also access all the national organization workshops on the SCORE website as well. So like I mentioned, I am a SCORE volunteer. I'm a subject matter expert, so I wouldn't be your mentor or business coach, but I would be just kind of somebody they would bring in for deep dives. And then I also do several workshops for SCORE based on different areas of expertise that I have. My biggest area of expertise is product development, product marketing. So I've worked for over 20 years bringing new products to market and many, many years. And part of that is pricing those products and services. There's product marketing as well with those. So I teach several workshops for SCORE. One's a new product development workshop, one's a pricing workshop because pricing is both art and science, and it's fun, but can be very challenging to kind of figure that out. I do also do a generative AI workshop and then this essentials of IP or intellectual property workshop because in my background, I've always been the one that dealt with the lawyers as well as far as branding. We always had, trademarks and copyrights and patents because I was in physical products. We deal with patents and even trade secrets and trade dress. So kind of always been the one that worked with the lawyers and then handled any kind of legal issues and worked with our in-house and external counsels on that. So that leads us to the legal disclaimer because now today's workshop, I'm not a lawyer, so I'm not going to give you like specific advice about what you should do in your business. Again, always what SCORE does is provide education and training and resources, but you still have to decide what you want to do with your business. What we're going to talk about today is not so much about how do you file for a trademark or how do I file for a copyright. It's more about what is a copyright and what things in my business can I protect, should I protect, why should I do it? It's the business side of intellectual property, not the nuts and bolts of like you file this, you fill this out, and here's the paperwork for it. But it's more about what are the things, how does intellectual property work from the business side? Because even when I worked with in-house counsel, they would give us the legal structure, but then we on the business side always had to decide what we wanted to do. They never would tell us, well, we should, they would recommend and they would say, here's the things, but it always we had to bring that legal reference into a business context and then decide on the business side how we wanted to proceed, knowing what the risks were and the benefits of going different routes. So again, you will still need to consult with an attorney once you kind of decide to do some of these things, depending on what you want to do. But this will give you the kind of before you talk to the lawyer, it's good to kind of have thought through this and know your goals and know why you want to pursue this intellectual property, whichever form it is, before you go meet with the attorney. So we're going to talk a little bit about what is intellectual property. It's a term IP, and I'll use that term a lot. We'll get thrown around, but what actually is encompassed in that term? The four different types of IP or intellectual property, and then we're going to talk about like IP strategy because we can talk about the different types, but then kind of what's my next step? What should you be going? Okay, what's the first step to kind of figure out my IP strategy? Because it is it's like anything else in your business, you need to have a strategy behind your intellectual property. Here's your plan, here's your goals, here's your next steps. And so you still have to decide what it is for your business, what you want to do, but you need to have kind of thought through your actions and how you want to achieve how your intellectual property fits within your overall business strategy. So again, we're going to view the IP through a business lens. So we're always going to think about it from how these different types of IP can protect your business. And depending on, and we'll all be at different points. So there won't be a everyone should do this and everyone should do that, or no one should do this, but it's going to be you're going to take this information and then figure out how this applies to your business because everyone's in different industries, there are different types of businesses, and there'll be different things that will be applicable to some and not applicable to others. We're going to primarily focus on US IP policies and law, not so much international. We'll touch a little bit on international only to kind of reference how it might be different from the US or if there's additional steps you would have to do for international, but we're going to primarily focus on the US. We're not going to, like I said, cover specific about how to file and documentations and the paperwork, but we're going to talk about it in the business lens and business context. Of course, you should always consult your attorney. You should always have legal counsel because for contracts and any kind of documents that you need to have to protect your business, you need to talk with them as well. But if you already have kind of your ducks in a row before you go meet with a lawyer, it'll just make it smoother, quicker, and be a much faster process when you do actually engage legal counsel. So what is intellectual property? Oh, and anytime, please put questions in the chat, like Michelle said earlier, and she can interrupt me. I have no problem if there's something on a slide and you need an answer to it then, or when we stop at kind of, we'll go about an hour and then we'll probably take our first break and I'll stay here to answer questions then so we can wait till then, or she can interrupt me. So please go ahead and put them in the chat anytime um, you have questions. It's not going to bother me, Michelle. You can always interrupt me. So what is intellectual property? So think about it. So we think about physical property. If I have a product that's a property or a location that's a physical property that I might own, intellectual property is creating a legal framework for creations of the mind. So it's the things that you have created that might not be a tangible physical product, but it still needs to be protected. It's still work product from your business, your mind as the owner, or in your other people that work for you in your business. But it's intellectual. So it's things that you think about and have created that you can then also protect, just like you would physical property. It's intellectual property. It gives the creators and inventors exclusive rights over those kind of mental or intellectual creations and innovations. So in the US, we're very good about if people can protect their work, whether it's intellectual or a physical work, that gives greater value to a business and that actually helps to stimulate the economy. So I just read an article too long about why the US model works is because we do have personal property, intellectual property protections, patent protections that are very strong. And that helps people. Like if I create something, I get the benefit back. I get the exclusive rights back to me as the inventor or creator. And it doesn't go out there for the commons. So I can it's worth my time to then invest in that idea and invest in that um, work product because I do get benefits to compensate me for all that investment I put up front. So think of IP as a way to kind of own ideas, just like you can own physical property. So it's kind of, which it says it in the name, but people get a little confused about what things can be protected under intellectual property, what can't. Not everything that you think of can be protected, and there's very specific classes, but we'll kind of dig into that in a little bit because it's really important that IP are things that you can't touch, but they're still work products of your business. They're still valuable things that can be part of your business, and you need to have protections on those around so other people can't come in and um, infringe on those rights that you thought of as a business owner. Again, these IP rights, intellectual property rights, give you exclusive control or exclusive rights over this creation, the thing that you created, how you use it, you sell it, you share it, whatever you want to do with it, it gives you the exclusive rights to do that. There are limited time periods, not forever, except for trade secrets. They're kind of a weird one in the intellectual property world, but that's very rare to have a trade secret. But most intellectual right, it gives you an exclusive right, but it's not forever. It's a long time in some cases, but it's not forever. And then IP protection is typically country specific. So That's why we're going to focus on the US, but other countries will have different, sometimes they follow the US law, sometimes they have their own laws. So we're not, it'd be too hard to cover all the international rights because every country is specific, but we're just going to focus. A lot of them follow US, but some are very different from the US in their intellectual property. So I'm going to talk a little bit about some misconceptions because I hear these a lot of times from people. They think IP does this or doesn't do this. And they're kind of the biggest ones that out there that I hear. The first one is that intellectual property protection is automatic and complete. Like it's a given that it's something is protected by IP law. And that is not the case. Some protections begin automatically for some things, but usually full protection requires federal registration. So we're going to talk about the different types of IP, and we're probably going to focus mostly on copyright and trademarks. That's the two kind of biggest ones for small business, and then we'll touch a little bit on the other two. But some are automatic when they start, but some you get some protections, but you get full protections if you register with the federal government. And we'll talk a little bit about which ones that is, and then what those protections entail. The other one's that IP is too expensive for small businesses. And I would say not having your IP, not having your trademarks or your copyright, your things protected can be way more costly because somebody can infringe on your ideas, your work product, your intellectual property, and you have no recourse. And so think of something essential to your business and somebody came in and copied it, like that could really hurt your business. So sometimes it is an upfront cost, and that's why we have to always evaluate this from the business side. And we'll talk a little bit about which ones are kind of when you do things and when you might want to wait, or what things you want to protect and what things um, aren't necessarily going to be protected. Because if someone infringes, and I hear about cases all the time where somebody will get infringed. Well, they didn't protect their IP, so they didn't have any recourse. They didn't, somebody can just take that idea and use the same thing, and there's nothing that the business owner can do. So it can be very costly. And there's cases all the time of copyright and trademark infringement on businesses because they didn't have the protections in place. Here's the when I hear that, well, if I thought of it first, it's automatically mine. It's not the case either. Thinking about it doesn't give you any IP rights. You actually have, there's very specific things you have to do to make sure that those rights are triggered and those rights get put in place. It's not just I came up with an idea and that somehow it's mine and it's protected. That is not the case at all, which I hear that one a lot. Well, I thought of it first. Well, thinking of it doesn't matter. There's very specific steps you have to take. They're not huge and not super burdensome, but you just need to know that those need to be done, besides just thinking about it. And then please, this is the one, if nothing else, please don't do this one. Um, Anything I find online, I can use for my business. No, you can't. I've had many instances where people like, well, I can use this images online, or this thing is online and I can just like download it and use it in my business. No, 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 don't ever do that. Most online content, and we're going to talk about copyright, is copyright protected, even if it doesn't have that little copyright symbol. And that copyright is, and that's usually the one you're going to infringe on if you, and I don't care if it's on Google Images. I don't care if it's, there's some specific ones that are listed for common use, and but they have to be clearly marked as that. But just always assume anything out there online, anywhere you find it, is copyright protected, and you can't just download it and use it in your business. So we're going to talk about the four types of IP, and you'll see these symbols on the right. These are the common symbols. Sometimes you can put the symbol, even if you don't see the symbol, it might still be might still be protected. So copyrights, which kind of cover creative works, trademarks are usually thought of as like kind of brand identifiers. Patents cover inventions and processes, and trade secrets, which is confidential business information. The two that we'll focus mostly on today is copyright and trademarks. Patents, again, if you have a physical product, you might work on the patent process, which in new product development, would do patents a lot. but it may not be as applicable. It's applicable for small businesses, but very specific type of small business. So we will touch on that. And then trade secrets, we'll touch on it because very rarely will you have something that would rise to the level of a trade secret. But I think the idea of confidential information, which is kind of a little lower bar than trade secret, is something that we need to touch on for small businesses, is more applicable to most small businesses. So let's talk about copyright. So copyright and trademark will be the two kind of biggest focuses for a small business. So copyright is any kind of creative work. So this is the one trade, or this is the one intellectual property that is automatic from the moment the creative work is fixed in a tangible form. So it's not just me thinking about it in my head. I actually have to fix it, which means it has to be written down in a document. It has to be, it's an artwork, it's a drawing, it's anything that's put into a tangible fixed form. And fixed can be a digital Word document. That's still fixed because you're putting it into you're writing it down so it's somebody else can actually see that same work. It's not just in your head. So that's the key thing, but it is automatic from the moment you create the work and you put it in a fixed form. So when you or putting something in your head and thinking about it, that's not fixed. But when I put it down, write it down on a piece of paper or in a Word document, then it becomes fixed and the copyright starts at that point. So these things protect written works. Yeah, that's like books, articles, that's website content, your marketing materials. Most software code will be copyright protected. People will think you can patent software code, and that's very difficult, but it's usually copyright protected. It'll also be visual works, photographs, graphics, artworks, architectural plans, audio visual with more like podcasts as well as like video, music. Of course, those come under copyright. And then compilations and derivative works. So sometimes you can um, do a different version of somebody else's work, and depending how transformative that work is, that derivative work, you can copyright it without infringing on the original copyright. It gets into a little gray area. It's mostly kind of with artwork that we see that, and how much you are inspired by an original artwork and how much you transform it kind of gets into a little bit of the gray area of copyright. And I wish everything was black and white, but there is gray in intellectual property, just like any other legal field. Nothing is very black and white. It's very rare. So usually there's shades of gray and kind of where things sit in intellectual property, just like anything with the law. What copyright does not protect is ideas or concepts. Again, it's not just the idea, or it's not even you saying the idea. It has to be fixed in a tangible form. It's not just you telling your friend about the idea. That doesn't give you copyright. It doesn't cover facts, data, or like information, statistics, any of that stuff is not copyright protected. It also doesn't cover, interestingly enough, short phrases or titles. So while a book content can be copyrighted, a book title cannot be copyrighted, which is very interesting that you think, well, why can't that be? It's just not. You also cannot copyright methods, systems, or processes. So those come under different intellectual property, but you can't say, here's my method for something, and that's a copyright. It's that method cannot be copyrighted. Some of the keys. So again, you have these, it's automatically created, but there are still rules around copyright. Just because I write something down doesn't mean it always follow fits under the copyright rules. So they must be original. So if I just copy somebody else's words down on a piece of paper, that's not original to me. Those would not be copyrighted. So they have to be original to the author. Again, we can talk about derivative works, and it's usually in art that we see this where, and the most famous example is always Andy Warhol's Campbell soup cans. So he was able, because he was considered, he filed for intellectual property copyright on his Campbell soup can artwork and he received that copyright because it was deemed that he had transformed the original soup can. It wasn't just a literal soup can. that he had transformed that into a new work. So it was able to be copyrighted. So that's where that gray area comes in. Um, Again, it must be fixed in that tangible form. So he just couldn't think about creating multicolored Campbell soup cans. He had to actually fix it in an artwork in a tangible form or in a screen print. There's very minimal creativity. So you don't have to be super original in the sense of like you have to come up with something. I mean, we all use language, so it's the way that you write the words and your ideas and thoughts on paper, as opposed to something that no one else has ever thought of before, and you write it down. So it can be pretty low threshold to creativity as far as your original works, but you just have to be your words and your ideas and your thoughts. Work for hire. So if you hire contractors for any small businesses, if you have an independent contractor or someone on your staff that does any graphics or writes website copy for you, all that, that is considered work for hire, and the employer owns that copyright work. And most independent contractors, like you hire a graphic designer, you contract with somebody, they know they don't own that work. They're creating it for you as the business owner, but you need to make sure to have in any contract that you own the intellectual property that person is creating. And that's very standard. Um, that it's a work for hire, and that's very clearly that copyright doesn't stay with the independent contractor or the employee. It is owned by the business, or the copyright is the property that whether the owner or the business itself owns that. There are fair use exceptions to copyright, and we'll talk about this because that's where people get confused a lot, because they see people using copyrighted material and think, well, if they can do that, I can do it too. But no, there are very specific fair use exemptions for copyright where you can use somebody else's, you can, use that copyrighted material in your work if it's, but it has to follow under very specific guidelines to use that. That's criticism, education, parody, and news reporting. We'll cover that a little bit later. Copyright, we're going to talk about first to invent, first to use, and first to file. Those are different systems within the intellectual property. Copyright is a first to invent. That's why it's automatic when the person puts that down in a tangible form. That's why it's a first to invent. That's when the copyright starts, is the first, when I've invented, meaning I've invented and put it down in a tangible form. That's when the copyright starts, regardless of if I registered or not. We're going to talk about registration versus kind of just in use, and then actually registering a copyright, or registering work to be copyrighted. So let's talk about that now. So again, we just said that copyright starts automatically when you put it in a fixed form. I can put in a Word document and I don't have to share it with anybody, but it's still copyright protected because I have put it in a fixed form, this writing. Now you should always have dates and things, like, and usually like digital, or if you handwrite something, put a date on it so then you know that's when your copyright starts. However, if you've got something like a lot of books and other material that is more substantive, you should probably look at registering that copyright with the federal government. And there's a U.S. Copyright Office. You actually submit the document to the government. You fill the form. You pay money, and that material is now federally registered copyright. Again, you wouldn't have to do every single thing, but things that are pretty much pretty key to your business, I would look at registering that material with the federal government and getting federal copyright registration mark. Whether I use it myself or I register with the federal government, I can still use that little copyright symbol, that little C. All that means is that it's claimed to be a copyrighted piece of work, whether I register with the federal government or not. So you can still use a little C. What registering with the federal government gives you is additional legal protections and legal advantages. So you have some because you just created it, but you get additional ones when you register for the federal government, because when you register that piece of work with the federal government, it clearly states that you think this is really important, and you're giving clear notice to others that this is copyrighted material and it is protected. Um, because you file it, the presumption in court is that you own this and it's valid. Like you don't have to prove that you created it. You don't have to this. The presumption is that it already is because you went and registered it, that it's valid registration and it is your work. You get extra damages if you filed it and somebody infringes on your copyright. Again, if you don't file or don't register, you can get some damages, but you get additional damages laid out by statute automatically when you file the federal registration and somebody infringes. You can recover attorney's fees. If somebody infringes and you have to go to court about it, you can recover all those attorney fees automatically as part of that infringement if you win. And then you're just in a stronger enforcement position because you've registered it federally. Again, you still have protections if you don't register with the government. You just get additional protections and it's much stronger enforcement if somebody infringes on that work. The length of protection for copyright this is a long time, but it's not, again, it's never forever. So individual creators is the life of the author plus 70 years. So a lot of the authors that you see, like every year, a certain number of kind of classic works will fall out of copyright because it's the life of the author plus 70 years. So that's a pretty long time. Corporates, like, so if that work for hire or businesses that have copyrights is 95 years from first publication or 120 years from creation, whichever is shorter. And then any anonymous works is the same thing kind of as a corporate. They get that same time frame of 95 years from when they first publish or 120 years from creation. So again, you can create something and not publish it. And the clock starts from that creation versus publication. So that's just some lengths and time. So you get a long time for copyright. When do not register copyright after you feel like you've been infringed because they're going to go like, wait a minute, you can't file for it after somebody infringes you. I mean, you could, but it's a much weaker position because then now somebody can say, well, no, I came up with it first. Here's look at mine. I came out, I had it before you even, filed any registration. So you always want to register at the beginning before you need any kind of legal recourse. It's not expensive to file for a copyright. These are just general, it kind of depends on the filing method and different things, but this is just kind of a general, copyright is that's why you see a lot of books and a lot of things, a lot of materials get copyrighted or registered with the federal government because it's not a huge, again, right now with the government costs might be going up, but it's not a huge burden. Now, if I was doing, you know, 300 things and trying to copyright, that's why you have to kind of think through your business about what's kind of some key content that you'd want to make sure to protect that would be, integral to your business and you wouldn't want somebody else to copy. Those things are the what you should look at be filing. Again, you can use that little copyright symbol, the little C, whether I register it with the federal government or not, you can still put, and you should put that little C on things because it gives, even though it's automatic, you don't have to use the C. Again, anything that you can do to notify others that you are serious about your intellectual property and that you consider this copyrighted material, it just helps stamp on there that you feel that you are saying to the world, hey, this is copyrighted material. Again, this is the one nice one that copyright, there is international protection. You don't have to file separately internationally because of this Berne Convention. About 770 different countries will kind of have the same, will follow with the US and give you automatic protection for your copyright. So again, if you don't have to file in every country, this is like one of the few intellectual properties that international law, because of that Berne Convention, everyone's kind of agreed that these are the general copyright laws that should govern kind of all works across most of the world. So let's talk about fair use because this is where we get tripped up a lot. Or I see people think something, they can use it because they see somebody else using it. It's never a good plan, but I can understand why that happens because you see somebody else quoting Shakespeare or somebody else, referencing this document or pulling this paragraph from this book into something. So you can do fair use, and somebody can do this with your work, even if you copyright it. There's permitted uses for which come under copyright law for what's called fair use. That's like literary criticism. So anytime I'm writing an article and I'm saying, well, I'm critiquing this other book, but I need to pull passages in from that other book or article or whatever into my work so I can give users or readers the reference back to what I'm critiquing. I need to give the original source and original material so I can make commentary on that. That's totally acceptable. You don't have to give permission. You're not infringing their copyright by pulling that in. Again, commentaries is kind of the same thing. News reporting, they can pull sources without having to get permissions because they're commenting and reporting on different things, and they don't have to get copyright permission because it's considered, you know, a societal benefit or kind of an educational benefit to it. Teaching, so if I'm in a classroom and I pull different materials, I can totally do that. Scholarship, again, research and writing published papers, all that kind of stuff. Kind of education or societal benefits, you can falls under fair use. But you can't use material that's copyrighted in your product, especially if you're going to make money off of it. So let's just think anything commercial use is not going to be considered fair use. If I'm pulling something in and then I'm going to do something with it and I'm making money or somehow it's for my business, for profit business, not going to be fair use. A lot of podcasters I see can get in trouble with this a little bit because they can use copyrighted material, but they will, especially with music, they will try to pull copyrighted material or music into a podcast and use it for free. That is not considered fair use, and they can be big trouble. If again, most people are going to say, "Hey, stop using my music," or pay me for my music, but they think that they go, well, I'm just using a snippet at the beginning or the end or whatever. It's like, no, because you're still using it for a commercial purpose, even if your podcast is not making money. Um, so that's one where, and the music industry is very aggressive in protecting their rights. So that's one like pay for the for the use of the music. Um, you can again there's consideration, but just kind of think if it's educational, society, commentary, then and it's just short snippet. You're not like trying to steal take the whole book, content and use it. You're probably under fair use. Again, this is where you still should ask a lawyer. If there's any kind of question about it, that's where you check with legal counsel, but just kind of know you can't just blanket take things in and use them in your business because or somebody can take some of your content and might be using it in a class somewhere, and that could be considered fair use because they're using it for educational or teaching or research purposes or commentary or criticism. So just kind of be thinking about that when you are looking at how fair use works. Oh, so again, you might quote a short passage from a book, like in a book review, copyrighted images for, if you were doing a presentation for like these images here, I actually paid for them to use in here. But again, if I'm a teacher in a classroom and I show a picture of somebody's artwork, I'm not infringing on their copyright because it's for kind of the educational purposes. And then the other thing is like parodies of songs you can get around the music copyright. So like I was thinking of like Weird Al Yankovic when he does his parody of a song, like he'll do Michael Jackson's song, but he'll put all different words and it's obviously a parody of that song. So even though the melody, the music underneath is the same, he's transforming it and he's allowed to do that as comedy and parody or another kind of um, exemption to copyright law. Not too many people are comedians, but you'd be okay if you did that that's why I like stand-up comedians can use material and they don't get in trouble because it's comedy and parody of that copyrighted material.
Sandy,
Yeah.
we have a question from Michelle, and again, I know I'm messing your name up. Wants to know if our training curricula automatically protected under copyright.
Yes, if you created it and it's like this content here is actually my copyright because I created, even though I'm doing it for score, it's still my content I put together and created. So I could put a C on every single one of these. Even if I don't put the little C, it's still my copyrighted material. Mhm. Good question. And in your training, um, like I said, because you're doing for education reasons, so that's where just be careful when you are using referencing other copyrighted material. So that would be the only thing I would kind of look at. Like, so these images I actually paid for, so I could use them in this because, but just kind of be careful of um that's the only thing it might be in your training is just reference. Because if you're using the training and you're selling it like as a course, then you're using it for commercial reasons, not for just like as a teacher in a classroom as education. So that might be the only thing to think about. Um, Key factors, again, commercial or nonprofit educational, that's kind of where the fair use comes in. If you transform the original document or thing that you're referencing, like the Campbell soup cans, he transformed those into a different medium and a different format and different look. He didn't just take the Campbell soup can and put it on in a graphic and use it exactly the same way. Anything factual versus creative, again, that's going to kind of, these are all kind of that gray areas of copyright and fair use. So you just have to kind of think through these. And this is where you should talk to kind of a lawyer if you're like kind of wondering about it. Um, the amount of the portion of copyrighted material you're using. So like if you're just bringing in a couple lines um, from referencing like from a book, like here's a quote or here's some things, um, that's going to be viewed differently than if I take like the heart of that book and I copy it over into my material. So thinking about that. And then the other thing, and this is a big thing that courts will look at is, and especially if you hear about these copyright cases, this will be a big factor. Does the does the use of the material copyrighted material that you're harm the market for the original copyrighted work? So if I publish something and I use somebody else's copyrighted material and I say claim it's fair use, they're going to look at, well, does my use of that material harm the market for the original? So to somehow like, oh, people, oh, I don't have to go buy the original because I can just buy this over here, basically. So think about it from a market or impact, which is kind of an interesting because if you've harmed the original person in their use of that material, then that's going to be definitely looking at as far as infringement. Again, it's not clear cut. Factors aren't weighed evenly. There's no like, you do this, you're infringing, you do this, you're okay. It's a case by case basis, which is kind of why it's very um, difficult for people, for even lawyers to say, well, you're good, you're not good. It's like, well, here's the factors are for you, and here's kind of the things against you. And then the judge has to kind of make a ruling based on all the evidence. I would say if you ever are in doubt about something or using copyrighted material is to just get permission from the copyright holder. Just sometimes they'll just say, like you may say, hey, I want to quote a couple lines for use in this slide deck or this training material. And they may go, and you just say, and they may just get an email, get it, always get things in writing. And they may say, that's fine. I'm okay with that. And not, most people are like, especially if you're kind of using it for kind of fair use, but maybe not entirely, or it's gray and you're not sure you want to get their permission, then it's always just the best. And a lot of times, um, there's the U.S. Copyright Office has a fair use index that might help give you a guide as well as determining fair use. And if nothing else, like the best practice is kind of attribute that original work. So if I pulled somebody's copyright, even if it is fair use and I sure I can use it, then I should still attribute back to that original author. So I should say this came from so and so's work. That's just always the best practice anyway, because then you're giving attribute and people could go back to that original work and find the original source. So those are always kind of good practices anyway. Copyright and AI, whew, that's going to be one that people are going to get. It's still an evolving field. Let's just say that. So any kind of AI generated content. So what I'm going to share with you today is kind of the current landscape. Again, it could change tomorrow. It could change next week because things with AI and law. And there's two things about copyright and AI. One applies to small businesses. One is going through the courts, but it's not really anything that's not going to affect small business in the sense of it's a separate thing. So there's the And this is anything AI generated content. So it could be text, it could be images, it could be videos, it could be audio. Now they're doing like voiceover, AI generated voiceovers and code. So that's a big thing that what developers are using AI to generate software code. Is that copyrighted or not? Because, you know, yeah, a constantly evolving area. Um, Here's what the US Copyright Office has said. Currently, works produced by machines without human authorship cannot be copyrighted. That sounds very clear cut, but in reality, it gets a little gray about how much machine, how much human, how much AI, how much the person. If it's the person's idea, but the AI just spits out the end result, is that copy, but is a human in the loop? So it's still gray. Um, but the key thing is that a human has to be involved in the creativity and the authorship for copyright protection. Again, AI assisted, not fully AI generated. I think that's where it's a little more. I mean, obviously, if the human doesn't know AI, you're fine. If the AI only does it and there's really no human besides like the prompt to say, hey, create X, and it's all AI generating, do nothing with it, probably a problem. But the most things are gray in between. So that's the one side. The other side of AI and copyright law is people are suing the companies that created these models, the LLMs, because they were saying that the models were trained on copyrighted material. That's a whole different step that's not affecting um, small businesses. That's a entirely separate issue between those copyright holders and the companies that created the models and the training data that was used. That's I don't really know how that's going to go. The genie's out of the bottle. We're not going to suddenly put these large language models, the Chat GPTs and the Claudes and the Google Gemini and all those. They're not going back in the bottle. So they're going to work out that side about what information was used to train the models and what copyright information was used. They'll figure that out. But we're still going to be able to use these models as a small business. Here's my general guidelines for you on copyright and AI. And these are, again, this is not the legal landscape. You still need to talk to a lawyer if there's like a gray area. These are just some general guidelines based on what's kind of the current landscape. Again, could change tomorrow. So if it's pure AI, so if you just put a prompt into Chat GPT or Claude and it just spits out a response and you don't do anything to it and you just use it as is, you're probably not going to have copyright because anyone could challenge that and say, well, the AI generated everything. The human, your prompt putting it into the model is not going to constitute enough human interaction or human creativity. It's going to be something that's probably not going to be copyrightable. AI as a tool. So if it helps you research, it helps you do some writing, it's you say, give me some brainstorm, some ideas, or give me some give me some research on this, or give me an outline for this. That's and then you continue to write and build out, you're just using it as a kind of a research tool, then you're probably fine because you're just using it like any other tool, like Google or any database of any kind. You're using it as a research tool, but then you're creating the content, you're writing the actual copyrighted material. You're probably fine. Here's where it gets tricky. If you prompt in, you have the AI, you do significant editing, maybe it's a 50-50, maybe you rewrite 50%. It's that one's the gray area. It's going to come down to how much what the human contribution is. If the AI is creating kind of a first draft and it's rough and you still go through and you edit and add more stories and that's why we always say never take what comes out of the model. You should always put your own voice and your own experiences and stories on top of that, just kind of giving you a framework. More than likely you're okay. That's where you should really kind of check with your legal counsel because that's really gray. It just depends on how much is your human contribution, and that's where the courts are still figuring out as people bring cases to the courts and lawsuits. That will get dialed in over time, but right now it's kind of still a gray area. The other thing too is you give it prompts and you do a little bit of editing, and maybe you give it and you go back and forth with the model on like, no, I don't like this, redo this, I don't like this, do this. You know, again, it's unclear because it's kind of that same thing where you rewrite it, but maybe you're just like telling it to rewrite it, and then it gives you something else, and you tell it to rewrite it again, and you say, well, add this and do this. You're giving more creative direction. That's again unclear. Your risk level is kind of medium. So just kind of be cognizant of those. Again, if it's like website copy and things like that, there's lower risk. But if you're writing like, a book and you're working with the AI on that, just kind of be thinking about how much is the AI writing and how much are you writing as a human, because that could get challenged in copyright, as far as like how much did you contribute. And you have to be factual about what you wrote, what the model wrote, and kind of thinking through. So that's as cases come to court, that will get, I'd say, clearer, but it's still going to be a case by case basis. So just kind of be thinking of that going forward. All right, we're going to move on to trademarks. We're a little bit early, but I don't know if anybody wants to take a quick break now and then get a trademarks, or if there's more questions. Because trademarks is another kind of big area.
We have a very quiet group today, Sandy. No, no questions.
All right, do you want 5 minutes or do you want just to continue kind of going?
So I take that back. We do have a question. When looking for an IP attorney, are there certain ones specific to helping us make decisions on the front end versus one who litigates? If so, what should we be looking for and what questions do we ask to be sure we are making wise decisions in hiring? Thanks.
Yes, usually a litigation attorney is not going to be the attorney you use. A litigator is only going to be brought in when actually a lawsuit happens. They would actually bring in a litigation because they have a very specific skill set in that area. Your for trademarks and copyrights, um, I would just check with your, like, it may not, like, there's a tax attorneys, there's people that will specialize in intellectual property. Whether they specialize in intellectual property, you need to make sure that they have that in their background, that maybe they might say they do like business law, which is more kind of employment, HR, kind of corporate, and intellectual property could probably be part of that. Um, but you can find people that specialize just in intellectual property. There are attorneys that will specialize that as primary. They might also do other kind of corporate law, like I said, employment is usually kind of the other one. That's the HR stuff where so businesses don't get in trouble with what they should be doing with their employees. Um, so they might be a kind of a corporate attorney, but they're gonna kind of call out a specialty of intellectual property. Now, I will say patent attorneys are a whole different breed. So, an intellectual property attorney could do trademarks and copyright and even trade secrets. They may not even do patents. They would probably bring in, there are specifically patent attorneys that's what and if you do patents, you need to hire a patent attorney because that is a whole different layer of complexity and specialization. So, even intellectual property attorneys will often not do patent work. But a patent attorney will do all intellectual property too. But he would just be more expensive because he's primary patents. Attorneys are expensive. Um, so I would try to find an attorney but most of them will have like their specializations in there. And then when you meet with them, then just ask them like kind of what experience have you had with copyright or with intellectual property? Has it been mostly copyright and trademarks? Is it mostly a lot, especially in Nashville, will be the entertainment business and it'll be a lot of music copyright, but that may not be. So you have to go, well, do you have other kind of experience, other kind of cases outside of the music industry if you're not in the music industry? But they will have they will call themselves out kind of an intellectual property attorney as part of one of their areas of expertise. Hope that helped.
Okay, here's another one. Am I violating copyright infringement if I search, find AI generated info? In this case, recommendations for justice
Mm.
involved reentry tips for seeking employment and convert the AI generated tips to poster form for a career fair.
So, um, so the question is that you're asking AI to generate the tips, if I'm understanding right. and then you're making a poster. More than likely, you may not be violating copyright, but you probably can't copyright that poster, that information that you're presenting because it was all AI generated. The Where AI got their information, that's a whole different thing. But I would say that you couldn't copyright that material because it is just strictly AI generated. I will say that anything AI generated that you use, you need to double check all the information because you cannot trust the AI. You need to find out what sources it's using if you're sharing statistics, especially so if you're sharing like statistics or facts, those are not copyrighted at all. So those even like you said, facts, data, that kind of stuff is not copyrighted. So if, but you want to know those source materials, where did the AI pull that? Because you should never 100% trust the AI is accurate. You should always go back saying, provide me the source that you got this information from. Especially if you're going to if you're going to then put it out as your business and put in a post in a public format. If somebody asks you, well, where did that come from? You need to be able to say, oh, this information, you got it from AI, but it was pulled from this source. So for credibility. Hope that answered that question. Yeah, cool. Always, yeah. You should come to my Gen AI workshop because we talk about never trust but verify, or not even trust, like just verify and check every, if it's especially for facts or things that you're putting, because everything that you do is representing your business, and you need to make sure that you know where you got the information from, no matter what your source you're pulling it from. All right. Anything else, Do you want to? Well, now we're right at the time. I don't know if you want to take a 5-minute break, Michelle, or if you want to continue
That
rolling.
sounds good.
Okay, because I could stop. I mean, I could keep going, but like I said, trademarks is another big area. So you have to buckle up, people. We're gonna we're gonna deep dive again. So probably it's good to take like a 5 minute. It's 9:58, so maybe about 3 minutes after. But I can stay
Very
here
good.
and answer questions. I'm all good. How do you find about the workshop? So Michelle, if you go to the bottom left-hand corner where it says www.score.org/Nashville, um, there's a link like see all workshops, and you can just go find them all there. And that's the ones that the Nashville chapter is putting out. It'll say like local workshops. So you can see, and Michelle usually she has up through November, and I think she's about to put up December soon. And then, she kind of puts like a month to two in advance so you can see what's coming. But I'll probably teach the Gen AI one in January. I'll probably do the pricing workshop in February, and maybe this one again in March, something like that. So I try to space these out kind of once a quarter kind of thing. And then there's also the Nash. So if you go to that just score.org, you can see and look at workshops. You can see national, like they're like webinars. They're not workshops, they're like a 1 hour webinars. So they're kind of shorter little ones about different topics that we may not offer locally. That could be something you're interested in too. Right. Give you another couple minutes before you get everybody to come back, about 3 minutes. So this is where I should have music playing, but I don't. I never remember. And I forget. Oh, Michelle, there was a question in the chat. I answered it while you were stepped out about workshops. So I just told them about the website.
No, you were right on. And now what National is doing is listing some of the area workshops as well as national workshops
Oh,
on our website.
nice.
Yeah, it's a good cross section.
So like Memphis or like if they're having them, we say area.
Yeah.
Okay.
Well, the area is Tennessee, all the way through Georgia and Florida
Oh.
and back
Oh,
through
so like this, like the
Mississippi.
whole southeast region kind of thing.
Correct.
Oh, nice. About one more minute. Oh, that's a good question. You see that one, Michelle, in the chat? If you want to read it out for the recording later.
Okay. Speaking of music, I wonder sometimes if I want to close a speaking engagement with an inspirational song, where would I go to ask permission? For example, I once saw a speaker use Happy by Pharrell Williams.
Yes, you cannot do that without getting permission and paying money to the copyright holder. So you could probably, my guess is that those would be registered with the with the US Copyright Office. The other thing is a lot of times with songs, you can look up um, in music, the label is the copyright holder. So the independent, uh, um, like Pharrell Williams doesn't own the copyright to he's the inventor of it, but the copyright holder is usually the publisher, like the music company, the whoever publishes the music. So you could probably find out who published that song and find out who the copyright holder is. They're they want you to know, and you have to contact if it's I don't even know music. I should know them. Like if it was RCA Records, I know that's not, but like, whoever the copyright holder, you'd have to contact RCA Records and say, I want to use this. And I will say, um, most people, it's very expensive. It'll cost you a lot to use a snippet of music as for that situation. They are very protective and very expensive for copyright. Um, People will do this is where people will do stuff and not get the because they think, oh, well, who's going to notice it if I'm speaking at a presentation at a conference? Who's going to know that I use Pharrell Williams' Happy Song? No one is going to. Um, or the organizer of the conference won't check. But the problem is someone in the room might know, someone in the room might go, did you get the copyright? Or if it's recorded and played later, or if it's live streamed, or if it's sent out as a recording, like there's any number of ways and I will tell you, music industry is very aggressive about having little bots go out and find any use of their music. That's like on YouTube. If you just are doing a YouTube video of your kid like dancing and the song is a copyrighted song, YouTube they'll track that and they'll shut that down and they won't because that background music is a song that you haven't paid. You have to prove that you own the copyright, the use of that you're allowed to use that copyright or that copyrighted material. So there are little crawlers out there, especially with music, to check to make sure that you are not infringing on any music's copyright. So I know people that would want to use it like in a podcast, like they just want to use a snippet of some song as like kind of their intro music. Nope, not if they have to pay for it. Now you can pay for, there's like artists will create. So what you might do is there are databases of songs that are licensable, like, and they're just like short snippets, like 30 second, 60-second kind of, people will artists will create kind of these little snippets, but they won't be the famous, Happy by Pharrell Williams, but it'll be music that could be like upbeat and happy, or, like different kind of um, styles of music that you could use for your walk on, walk off kind of music. And you pay a licensing fee to use that music, but it's much, much, much less expensive than a real name brand pop song. My guess is unless that speaker was like super, like, I don't know, prominent. My guess is he did not get happy. He did not get whoever owns the copyright to Pharrell Williams' Happy Song to use it. You have to be pretty big. Like, I'm trying to think of like those big speakers that make hundreds of thousands of dollars. Like that's their gig, is they make, 25,000 a speaking engagement. They probably can, pay for the song. All right, let's go ahead and get started with trademarks. Because next to copyright, trademark will be the next big thing in for your business. And trademarks there's two forms of trademarks. Even though there's three symbols on the screen, and we'll talk about why there's three symbols for two trademarks. So trademarks are brand identifiers. So again, different than copyrighted material. You're not going to trademark a book or trademark your website content. Trademarks are, again, they're more like, think about your brand. It's like a name of a product, or it's a process. You may name like a label. Your name of your course might be trademarked, that name. It could be a method or a process. Like, you might trademark the name, even though you're not trademarking or copywriting the process. You may say it's the, Sandy DeWall method of blah blah blah, and you might trademark that title for things. Think about any kind of brand. Um, it's the logos and symbols and anything like kind of that. Your brand identifiers in your business are what's protected under trademark, not copyright. They are automatic, trademark rights are, but the big qualifier for trademarks is they must be used in commerce. You can't just have a trademark. It has to actually be used in commerce. It has to be continuously used in commerce to maintain the trademark. So if I'm Coca-Cola and I trademarked the Coca-Cola name, I have to use that mark in commerce. I have to put it on physical products. I have to put it in my marketing. I have to put that everywhere. And I have to continuously use that mark. If I stop using that mark, I lose the trademark protection. So it's automatic, but it requires that you have to use it in commercial applications. I can't just have the logo sitting on my computer on my desktop and not be used in commerce. It has to be used in commerce. That means in your business, out in the market, so that people can see it. So that's your business names, logos, slogans, product names. You can actually also trademark distinctive colors, sounds, or shapes, or packaging. That's called trade dress, which is a subset of trademark. So the Coca-Cola bottle shape is a trademark under trade dress, because that Coca-Cola bottle shape is a distinctive packaging. If you ever listen to any kind of like Netflix, or there's the little do do do, like the little sound, they call that something, I can't think of it, but that sound of like, it's called audio branding. And companies they'll trademark that audio sound, that's because it's tied to their business. So or like the NBC, was it that do 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 thing, whatever. So that audio snippet can be trademarked because it's a sound under trade dress. Trademarks can be used to identify physical goods and products. So there's two types of, we call them all trademarks, but there's technically trademarks and service marks. But for our purposes and for most things, we just reference them all as trademarks, even though they're technically, that's the TM as a trademark and the SM is a service mark. So trademarks are used to identify goods and physical products. Service marks are identify services. So if I had a service-based business, I might actually get a service mark, an SM versus a TM. But for the same rules apply to both. So for our discussion, we're just going to identify them all as trademarks, even though technically it might be a service mark. So like McDonald's as a restaurant is actually McDonald's is a service mark because it's describing the service of food, a food service business. But the Big Mac would be trademarked because it's a physical product and not. So that's why McDonald's could be a service mark, but the Big Mac could be a trademark. It's kind of splitting hairs, but an attorney will know which one to file for. But just know that sometimes you'll see SM, it's just a service mark. The R is when that trademark, whether service mark or trademark, gets registered with the federal government, just like with copyrights. However, when you register with the federal government, then you can turn that TM or SM into an R. And again, that signifies an additional level of protection. We'll talk about that. So just kind of know that's why there's an R versus a TM and an SM. So the key rules for, again, a trademark, just like anything else, you can't just say it's a trademark and like think you're good. It must be distinctive and it must identify and distinguish your goods and services. So you can't just use a generic word um, like like pizza. You can't just trademark pizza because that's not distinguishing. It's not distinctive, which is one thing that with so many trademarks out there, it's kind of always hard still to come up with a distinctive one, but it has to be distinctive and it has to distinguish your goods and services from others. So it can't be too close to somebody else's trademark. Again, it has to be used in commerce. So you have to actually put it on your products, services, websites, marketing copy, marketing brochure, information, brochures, handouts, flyer, whatever it is. You have to continuously use that mark in commerce. It can't be descriptive. It can't just be fast pizza, but Domino's pizza is distinctive. So, because a domino and a pizza, that seems a weird combination. So that's distinctive for that. But it can't just be like fast pizza or speedy delivery. Those things aren't trademarked because they're just too generic. Can't be confusingly similar to other trademarks. So and that's where it gets to be can you have to be thinking about because the idea is that you can't cause confusion in the consumer's mind. If it's too close to something else that's already out there as a mark, then it's going to cause if it causes confusion for or the possibility to cause confusion for the consumers, then it can't not be trademarked because it's too close to another mark. And trust me, people will search for marks that are so close to theirs that could be infringing. So that's when you have a trademark, part of all these intellectual properties is enforcement and to make sure that if anyone infringes that you take action. And we'll talk about why that's important. Use the TM or the SM symbol before registration. If you file again with the federal government. So again, you don't have to file with the federal government. You can use a trademark in commerce and still say it's a trademark. But again, filing with the federal government gives you additional protections that you wouldn't have otherwise. So when you file with the federal government, that's when the TM and SM turns to a little R, and that stands for a registered trademark. Trademarks are also, when you file with them with the government, or even when you use them without filing, that they're only good for certain for classes and of goods and services. So I don't get a trademark. So if I'm Coca-Cola, I have a trademark for the federal government has different classes of goods. So I have a trademark for food and beverage or drinks or there's different kind of trademarks there. I probably also have filed that trademark for clothing because I'm putting that on. I have apparel and thing merchandise. But I Coca-Cola has not filed a trademark for that name on like tires because that would be so outside of what their products and services are. So you don't get a trademark for every kind of goods and services across the entire spectrum. You have to file for each class of goods and services. So, and there's a cost to filing for each kind of class. But just so think about it. So if you have a trademark, you want to file for your specific industry that you're selling your products or services into. But then also think about, okay, I probably have to file that trademark for like merchandise and apparel because I might be selling t-shirts with it on, or if I have any kind of a clothing line, or, you know, or I might be offering some accessories. So I may have to think about different classes that I also have to file that trademark to be able to use, to be able to get protection. Again, I can still use it, but I have more protection if I've registered it in those multiple classes. And then you have to have continuous use. If you stop using it, and you have to prove that you're using it to the to federal registration. So even if you don't file with the federal government, somebody starts using a trademark similar, but you stopped using it in commerce, then you have abandoned those rights, and it could result in losing your rights by through abandonment by non-use. Trademarks, like different than copyright. Copyright is a first to invent. Trademark is a first to use system. So the rights go to whoever first uses that trademark in commerce. Again, it's commercial use establishes the trademark rights, not when you thought of it and not even filing. So that's the other thing too, is you, even if you file, if somebody else out there, like say in a different state, is using the same trademark in a different state, they were first to use. So they probably still have, they wouldn't be infringing because they, if they could prove they used it before you started using it, or before you started, even if you filed it with the federal government, as long as they can prove, and they can because you have to use it in commerce. So it's pretty easy to say, look, I can show I had it on my packaging. I had it on my marketing brochure from, this date to show that they were used. So they would have rights to continue to use that mark. Again, so that's kind of the thing with, is the first to use. That's why it's also good for federal registration, is it helps prove that you're first to use, that you aren't that you've filed for that, and you have that kind of as additional legal protection. Because people would, if people start using it afterwards, it's clearly you've established when you started using it in commerce. Even if you were using, and then you could also say, hey, I started using it 2 years ago, and you could show history of when you started using that mark. So length of time, again, nothing is forever in intellectual property. Well, this one's kind of forever, but you have to do certain things to maintain that forever. So it's potentially infinite as long as you maintain the mark. There's very specific things you have to do to maintain it, and you continuously use it in commerce. You cannot have a time when you don't use that mark somehow in commerce in your business. The initial term when you file with the federal government is 10 years. So you kind of have 10 years for your first registration, and then you have to get renewals after that. But you can have unlimited renewals. You just have to kind of go back to the government saying, yeah, I'm still using it. And you have to kind of prove that you're still using it in commerce, which if you are, it's not really a big deal. You just have to file some, like, here it is showing a, you know, me using it in commerce. Um, and then between 5 and 6 years, like between that 10-year mark, about halfway through, they kind of want to say, are you still using it? They just want to check in with you before the 10 years. So there's a declaration of use that you have to file to maintain that registration. Again, it's just a document. Whoop, you just prove you use it. The key thing is that you have to prove, and I've done this many times, um, they will want a physical picture of the thing in use. Like I've done some things where it was just like a digital, like, oh, it's on this packaging, and I sent the, like, a 2D rendering of the packaging to the, and they go, nope, that's not going to count because I can create any kind of digital thing. I had to actually physically take a picture of the box sitting on the floor with the mark on it to show it was physically in commerce, and I proved that it was in the market. So just kind of think through that. Sometimes you think a digital, like, but like a marketing flyer that had a date, copyright. When you copyright, you should copyright like 2010 or 2025, a date on there. So you could say, hey, here's my marketing flyer. Here's the copyright date to prove, and here's my mark on this flyer. So that would be something you could do if it's like, especially if it's more of a service mark. So when to trademark something. So think about, you don't have to trademark everything or register everything. So, but you can use a trademark symbol even if you don't register it. But think about registration. when that trademark is kind of key to your brand identity. You want to make sure you protect those kind of iconic thing, it's your logos and it's your, business name. We'll talk about that. It could be a very specific product names. We would trademark all of our product names. It could be your signature course. It could be your signature um process. So the process itself is not trademarked, but the name of, if you've named it, or like you offered different packaging, like bundles of services, you might name those service bundles. It might be, think of things as somebody else infringe and it causes confusion for your consumers. Is it going to hurt your business? Those are the things you want to think about. Do I trademark? Um, or filing the federal trademark registration. The cost can be 250. I mean, it's not astronomical, but it's not super cheap either. Plus, if you're doing multiple categories of goods and services, that kind of can add up over time. But just think, so you want to really think about the things that you want to register with the federal government. Again, you can still use them as trademark. You should still TM things. You should put TM behind any kind of brand identifier, even if you don't federal register with the federal government. Because again, putting a TM signifies, it just gives people notice, anyone notice that you consider this intellectual property is protected. It's just kind of like putting it out there like, hey, even if I may say it's a trademark and and I know it, like copyright, even though I know it's copyrighted material, putting that little seed just shows that you're serious about it and you know that you have rights, and you're signifying to others, I know I have rights. Don't infringe on me. Um, and then again, you must demonstrate in use. So you have to submit physical proof of the mark in use, which I just mentioned about the product or packaging. Whatever it is, you have to show a physical service marks. Again, it can be marketing copy, it can be marketing flyers and other things, but you need to make sure you have dates on things. So it has to be, you can't just say, if they can't tell when that flyer was created with that mark on it, then you're pretty weak in saying, well, I put this out a year ago. Like, well, there's nothing on there that tells me. That's why you want that copyright with the date, because that's going to help bolster your case of, I've used this in commerce starting this date, or I'm continuing to use it, and here's the dates. As I update this flyer over time, that date changes, and I'm showing I show the original one, and I show the continuous use of it in the marketplace. So that's why the trademark, whether it's trademark or service mark, it's called common law when you don't file for the federal registration or the federal registration. So we're going to kind of talk a little bit about both and what protections you get under common law and the additional protections you get under federal registration. Again, still have some protections if you don't file. You get more protections if you file with the federal government. So again, common law, you still have rights just by using that trademark and commerce. They start automatically when you start using that mark to identify your goods or services. So again, that happens automatically once you start using it in commerce. Federal registration, you file with the USPTO, which is the U.S. Patent and Trademark Office. So different than the Copyright Office, but still a government agency. You have to meet those legal requirements. I just said you have to submit the documentation, you have to fill out what class or goods or services that you're in, all that stuff. And then this creates that federal record of your trademark rights. So it's saying, it's kind of giving that, it's a little extra work, but you get extra protections for doing so. The key things on the common law is that it's going to be geographically limited. So your rights to use that mark will just be in the areas where you use, in the geographic areas where you use the mark. So if you're a local small business and you just have a storefront and you're only going to be in the Nashville area, then you may not need to file the federal registration. You may be fine with the common law because you're just going to be a regional local business. And you may not feel the need to protect it federally because you're not going to open a shop in California. Again, your rights are based on the first use in commerce in that area. It is harder to prove because you have to really keep your documentation of when you're using the mark over time. Like you can't just say in the very beginning. I mean, obviously, if it's your name on the front of a business store, then that's easy to say it's in continuous use. But if you're a service Or there's other things in your business, like it's the name of a product or process. That's not going to be on the storefront. That you have to document when you started using that and show proof that you've continually used that name um, in commerce the entire time. And then just again, like with anything, it lasts as long as you continue using the mark. Federal registration gives you nationwide protection. So it doesn't, so if you're in Nashville, but I federally registered, now that registration applies to all of the United States. Again, it's not international, but it applies to the whole US versus just kind of the area where your business is located. It gives you evidence of filing or first use. So it's very clearly, you don't have to go back and like remember, well, I filed it. I mean, you started using it, I think in 2000, I have clear evidence of when you're starting to use that mark. It gives notice to other companies because most other companies, what they'll do is they search, and we would do it all the time. I would search the USPTO's database for, if I was thinking about registering a trademark, I would go search that database first because clearly to me, if somebody has registered that mark, then I'm going to be able to find it really easy no matter where in the country they are. And I know then I need to get, if it's too close, and then that's where I work with the attorneys about too close, not close enough, different goods or services. I can see everything about that and know whether we should file or not. Um, and it gives notice to other companies that are searching. They go, oh, okay, I don't, it'd be too close to that when the attorneys say, so let me look for a different name. So it just kind of gives them, it was nice for me when people federally registered because it was just easy to find anywhere in the country. I don't have to figure out somebody in California, I might be infringing their trademark and I'm in Tennessee. But because I federally registered it, I knew I'd be infringed because we were a nationwide company and we were selling goods and services across the US. Again, the duration for the federal filing is 10-year renewable terms as long as you continue using the mark. So
Sandy?
just, oh yeah.
Oh, I'm sorry. Um, I have a question. Should you trademark the name for an event production company?
So we're going to talk about business names here in a second. So hold on. I think I might
Okay.
answer that one.
And the
Because
next one, how much does it cost to register a trademark name to the federal government?
I think I had that slide earlier. It can be 250 to 750. It depends how many classes that you're registering that mark with. So it can kind of, it's not, if you're just doing like one class of goods and services, a couple $100. But if you're doing, like the Coca-Cola was a food and beverage and merchandise, apparel and glassware, because I sell glasses and like they probably have their trademark registered in 10 different classes. Each one of those would be a filing on top. So that's where you can kind of start adding up your cost depending how many. So say a couple $100 for the first one, and then you kind of keep adding that in for the other goods and other classes of goods and services.
Okay.
So just consider common law. If you're really local and you have no expansion plans, you're going to kind of stay in a certain area. You may not need to federal register yet. You can still use that trademark. You should still search to make sure in your area you don't infringe on somebody's trademark. That's best practice, but you may not need to file federally. Or if you're still kind of testing the business concept and you think the name might change, or you're not quite sure that this is the product name, or that testing phase, you may wait until you kind of solidified this is my process or this is my name that I'm going to trademark. Federal registration if you plan to expand geographically. If you sell online or plan to sell online, think about a federal registration because you're going to be across the entire US, not just locally. And then if you really want to, if you have competition is pretty high, and you want to deter competitors from using similar names, again, for me, it kind of signifies, hey, I'm serious about this trademark protection. I filed it with the federal government. Any company what they should do is always search the federal trademark registration database first before filing. And if they see something similar, then it's kind of like, oh, it'll prevent them from, um, deter them from using a name similar because I know that's it's clearly they've been notified that there's an issue or they could be infringing. They can't go, oh, I didn't know there was a company in California, kind of a thing. But you can say, hey, it's the federal registration trademark. You should have checked that. That's on you. and it gives you a stronger position. Here's the thing I talk about business names. So there's special cases that are often assumed that they are protected by trademark law, even if they're not. Business names. So registering a business name gives you a legal right to operate in the state. That does not necessarily mean that that automatically gives you the federal like trademark protections because you're filing, yes, with a government entity, but it's just a business name. It prevents other businesses from registering an identical name. Doesn't mean they can't use that name in their business somehow, but just saying they can't use it as a business name. So you're not automatically registered under trademark law. So if I was doing a business, I would definitely want to say that if my business, like sometimes business names are like, it's the parent company, but it's not the name you operate as a business. So it might be, you know, DBA Holdings is the parent company. And then, so that's the business name, but then you actually operate as Joe's Garage. I don't know. And you, so that's the name out to the public. So you would probably want to trademark. You may not need to trademark DBA Holdings, but you probably need to trademark Joe's Garage because that's the name that's out in the public and is on the storefront. And if you have an event name, so if you so the question earlier whether it's just a business name, but you might trademark that, but you might have a different name for an event. So say you have a conference every year, or you have some kind like Bonnaroo, they've trademarked Bonnaroo as a name of the event, even if the company putting on Bonnaroo could be something super generic like DBA Holdings, because no one cares. But that name Bonnaroo would be trademark as an event, for that event. Domain names are not trademarked. So they are not registered. They are registered with a company or with an entity called ICANN, but that does not mean that they are trademark registered. That's a different thing. People sometimes think domain names they're registered with ICANN, but not with the USPTO. However, domain names can be part of a trademark infringement case if your domain name is similar to somebody else's. That can cause confusion. So if I tried to use a domain name Coca-Cola 123, I can guarantee you Coca-Cola is coming after me for trademark infringement because Coca-Cola 123 is too close to coca-cola.com. So my domain name is not registered, but it can be part of a trademark infringement case. Or if I did Best Nike, Nike's coming after me because there's confusion for consumers that Best Nike might be part of Nike, the company, not my little startup over here. So and then social media handles. People think those are trademarked. Nope, they're not, cannot be. So they're not registered. So somebody could be, that's why you have, you know, Joe's Garage 21 and Joe's Garage 22. You that they can do that because there's no trademark law that protects social media handles. The Your best practice for that is just kind of registering your same username or handle with each platform, whether you're using them or not. So that just kind of gives you've kind of are holding that space, even if you really don't use that platform, but it's just good to have. So then somebody else can't use your same um, social media handle or username on different platforms. So that's just even if you don't ever want to be on TikTok, you might want to go get your same social media handle on TikTok, even if you don't want to use it, just to protect that space from somebody else coming in and using it. All right. So did that answer the question about the event business question earlier? Oh, is there other questions? Because we're going to move on to patents. And I probably have to move. We're going to go through a little quickly through patents and then trade secrets. And then I'm going to do a little bit of kind of an IP audit, kind of like where you should start with doing your IP strategy. Anything else, Michelle?
We have, although I'm considering changing my business name, it's basically my name. I will definitely keep my tagline. Would you recommend I register my tagline? And if so, would that be a trademark registration?
Okay, so this is where I would say, talk to your attorney and your accountant and stuff. You can have a business name and then you can have a DBA, doing business as, under a different name. So it's DBA Holdings, could be my business name or your name. It could be Sandy DeWald, could be my business name. But then I could do a DBA under that name for um, Joe's Garage. Just come back to Joe's Garage. Um, so it's still under my same business name, even though I'm doing a DBA. It's like doing business as this other name. So that could be an option without having to file or change that, because you have to talk to your accountant and your lawyer about the cost and headaches of changing the actual business name versus just adding a DBA under a different name that you want to operate in the marketplace with. The other thing is your tagline. Yeah, so a tagline should be trademarks. If it's like iconic with like, it's like the Nike Just Do It. Just Do It is a tagline, and they've trademarked that thing. So if you have a very distinctive phrase that is kind of synonymous with your business that you want to protect, that would be, and that'd be different than a business name. So you could have your business name trademark, and then a tagline could be a different one that you also trademark. Um, so I would definitely, anything that you would not want a competitor to come in and start using, you should think about trademarking. And that would be a trademark. It wouldn't be a copyright. And any kind of short phrases like that would be their trademarks. Yeah. Okay. We're gonna move on to patents. Again, I'm probably gonna run through quickly unless somebody puts in there that they are considering patents. I'm just gonna kind of talk about it because it's a very specific area of intellectual property. And it applies to a really small subset of companies, but it's just good to kind of know what a patent is. Again, a patent, this is where it's not automatic. So this is where I said there was first to invent, first to use. Patents are first to file. It's whoever files, and they have to be registered, they have to be filed. You have to file a patent application with the federal government. If you don't file, you get no protections. You got nothing. So the rights go to whoever files first. That's why it's critical to kind of file. If you're going to do a patent, you better be filing for it. It's new inventions, processes, machines, improvements. You can patent chemical compositions. You can patent software, but it's not the code itself. It's kind of it's the methodology of the code. It's a very subset of even patent law. Very confusing. Um, and you can patent ornamental design. So there's multiple kinds of patents. There's utility patents, which is function based, and that's the most common. It's how something operates, and that's what you're patenting that. It can be design patents. So when a company's really utility design patents are two. Design is just the aesthetic appearance. So we would have products where the design that on the outside of the product was critical to the product. And so we would have a design patent on the aesthetic appearance of products. And then there's plant patents, rare, but that's more like new varieties of plants. So in the agribusiness, they do plant patents all the time. I've never done a plant patent, but that's a very subset of a subset. Patents have to be novel, so you can't just get anything patented. It has to be new and not previously disclosed anywhere. Once you tell somebody about something, like you publicly disclose it, you've lost your rights, and you haven't filed with the government, you've lost your patent rights. I mean, this is a very tricky area of law. It has to be non-obvious. So it can't be an obvious improvement to someone skilled in the field. So if I took a toaster and it's a 2-slice toaster, I made it a 4-slice toaster, I couldn't patent the 4-slice because it's obvious that you could just add more slots to a toaster. Like that's not novel, and that's pretty obvious. I could just put more things in. It has to be useful if it's a utility patent. It can't just be, or again, a design patent doesn't have to be useful. You have a 1-year deadline. You have to file within the 1 year of first public disclosure, sale or offer in the US. But however, we always tell inventors, we need to file before you publicly disclose, because if you've disclosed, you lose, there's some international rights that you lose when you publicly disclose without filing for the patent application. And then it's anything you file for a patent has to be public knowledge. So you have to put in your patent how it works. Somebody else could go and make that same product then, because you have to list all the specs, you have to list the drawings, you put the engineering specs in there, you put the engineering drawings, you list how it works, you list the materials. because a patent requires that public disclosure. But because you're disclosing it publicly, it's very clear when somebody infringes because they go, well, it's all right in this patent how I did it. And anything you do, it's very clear that you're infringing on this patent. But you have to disclose it so somebody knows that they can't do that thing. That same way that you're doing it. It's a first to file, so whoever files first gets it, not who invented it first. Um, Patents are either 20 years or 15 years from the filing date. Again, doesn't matter when you invent it, matters when you file it. There's maintenance fees and there's no renewals. So at the end of the time, the patent expires, and whatever was patentable is in the public domain, and anyone can use it. Anyone can make products at that point with that same design. Again, just when you have significant innovations, competitive advantage, or when you have licensing potential, you have to patent by country. So you have to patent for the US and you have to patent for every single country that you want to internationally that you want to, it's separate. There's not one for all. Can be very expensive. So you can file a provisional patent. That's going to cost you around $2,000 to $5,000. A full US, and then you have to file the full patent within a year. And that can be 20, 25 grand for a patent in the US. Internationally, even more expensive. I've seen patents depending on how many countries. So you can start at 100,000 for international patents and just keep adding because every country you have to file separately. And even if you can file like the EU, but even then you got to file in Germany, you got to file in Britain, and you got to file in, every country, even within like an EU block. It does give you exclusive rights. And so a lot of times people will file a patent and then even if they don't want to make it themselves, you don't have to make it. You just file the patent and you hope to license that technology out to another company to make it, or you can just file the patent and never make the thing. It's just filing it and you get the patent. It's, um, the idea is that you can either make it or you can maybe license it or do nothing with it. It's very complex. You got to hire a patent lawyer. Bottom line, you can't, this is not even a regular lawyer. You have to get a patent lawyer because it's such a complex process. Trade secrets. I just want to talk about this one because sometimes people think things are a trade secret and they're really not. Or they say, I'm sure that's a trade secret. Like, no, it's just confidential information, but it's not a trade secret. Trade secrets have very specific terms around them for intellectual property. You can have confidential information that does not rise to a trade secret, but can still be confidential information for your business. So trade secrets go to whoever can prove they created it first. Um, Trade secrets can protect like customer lists, formulas, recipes, processes. There's some very specific manufacturing processes. It can be your strategies, your pricing information, software code can be trade secrets. A lot of times software code might be a trade secret. Instead of even under copyright. So there's different things in your business you can make a trade secret, but it's such a high bar to get to a trade secret that most things are going to fall in the confidential information, but they're not going to rise to the trade secrets. And you still need to protect that confidential information. So if I have my pricing strategies, you've got or my customer list, those should be considered confidential information and be marked as such, even if they're not a trade secret, because trade secret has a whole nother level of of um, steps that the business has to do to make it rise to a trade secret. So a trade secret has to have economic value. So you've got to have, it's got to be worth something. You can't just say, I don't want anybody to know this, but it has no economic economic value in your business. It has to be a secret. If you have a trade secret, you have to take very specific steps to keep that secret even within the company. You can't have wide access to everybody. It has to be protected in certain areas, or if it's a physical, you have to do steps that even within your company, it's not widely known. Um, there's no registration process. And again, it's the first to invent, whoever uses that right. So we would have like the Coca-Cola formula is like the most iconic trade secret. It's even within the company, nobody knows the whole formula. And people may know pieces and parts for their area, but it's not widely known. You can't access, it's restricted information to only a few people need to know the Coca-Cola formula. We would have chemical formulas and products that we'd make, and people may know the ingredients of things, or they may know their part, but they know, and like The formula itself was considered a trade secret. It was only a small set of people knew. It was not widely known within the company. We had to take very specific steps to keep it as a trade secret and not have it widely known. Um, Length of protection for trade secret is potentially infinite as long as you keep that secret, which is hard over time, but it can be. Coca-Cola formula has been around for 100 years or whatever. No one knows the formula, right? So that's been, but they're very clear about how they protect that trade secret. And again, um, you have to know that there's going to be an impact, an economic impact if that trade secret were to be discovered. So that's part of that economic value of that trade secret. Again, very not usually going to be listed for or not usually applicable to small businesses. But what I do want to talk about is types of confidential information. So these are not trade secrets, but you still need to think about these as confidential information in your business. So that's your customer list. It's your suppliers list and vendor relationships. It could be your pricing strategy and your profit margins, business strategies, financial information, your employee information. We have all kinds of things around employee that, those are confidential information, and you need to make sure to take steps in your business, or you use software and other things and just processes that keep that information confidential and not let it get out into the public. That could be things like non-disclosure agreements. So we would have NDAs with some key employees in certain areas. So if they left the company, they couldn't talk about our pricing strategies they went and worked for a competitor. They couldn't, we had NDAs in place to protect, our pricing strategy or our customer list. They couldn't take those with them. In their head, they had them, but they couldn't take theoretically like financial documents out of the company when they went to work somewhere else. You need to train your employees on confidentiality, what that means. You need to clearly mark documents as confidential. So if I were giving um, a presentation, or if I shared information with a vendor and this was confidential information, then I would want to make sure to just type the big words confidential on a slide or a document, because that signifies that you're treating this, and even though you're sharing it with this third party, that you consider it confidential, and part of your agreement with them is that they're going to keep it confidential and not share it. So it's just, you have to really clearly mark those documents as confidential. And then you would never want to just throw your confidential documents in the trash. You need to always shred them, that kind of stuff, to make sure that you're securely, if you had any printed documents. So we're going to talk a little bit about IP strategy. We're running a little short on time. So we've done there's a lot of things here we talked about. First, I want to talk about where do you go next? Because you're like, oh, what do I protect? What I got all sorts of stuff. So I always say, kind of like, go through your business and do like an IP audit. So just kind of look at what intellectual property assets you have. What creative works do you have? What makes your business unique? What confidential information? Just kind of go through and start like, is it your business name? Is it a tagline? Is it a name of a course? Is it a book? Is it a workbook? Is it a process or a method? Like, go through and start thinking about what are the key things that makes your business unique and gives you kind of creative works that you have. It's your website copy. It's, you know, anything, logos, taglines, slogans, things. Now, if you may use a name for a campaign and you're not going to use it again, I probably wouldn't worry about filing for a trademark. But if it's something that's core to my business, like just do it with Nike, I probably do it because I'm going to be using that over and over and over again. Um, I would look at your, distinctive packaging and trade dress if you had any. Um, those trade dress is probably a little harder because you have to be really consistent, because your brand logo, your colors can still be colors are very hard. I worked for a company that we actually had a very distinctive color that we protected under trademark as trade dress, but we had to really enforce that color, and it was only good in that class of goods or services. But we were aggressive about anyone in that class that used that color of any shade, we went after. So, those things are it's harder for a color. So I wouldn't worry about maybe colors in your business, but your logo of your business, your name of your business, your key products or services, if you name those things. Again, any kind of content that's substantial, think about, do I file for that copyright? So just kind of going through all that. Um, you'll get this later too, but just kind of here's just a list of things that might be things to start looking at to see, hey, is it worth, am I good with the common law protection if there is any, or do I need to file for the federal registration? So just kind of looking through all the things, assets in your business, because you have more than you think you do. Everyone likes to start going, oh, wait, that could be protected. Yes, these things could, but do they rise to that? That's where your decision as a business owner. You can talk to an attorney about it, but again, they're not gonna give you the answer. They're gonna say, well, it can be. Do you want to? And it's up to you to decide based on, again, your strategy, what fits and what should be rise to additional level of protection, or what's good with like kind of the common law protection, or what can't be protected. Prioritizing, again, if you have like budget considerations, we all have budget considerations. So think about what's the most valuable thing. What are the kind of first things that you should protect? What would hurt you the most if a competitor copied it? What fits in your budget? So start thinking about prioritizing your IP. Maybe you can't do it all at one time, but you can start looking at, okay, I really need to get my business name, or this is like a key um, product or service offering, and I want to protect that name. Like there's certain things you might start kind of prioritizing based on your budget. Again, you've got to, and then once you protect it, you need to make sure that all employees or contractors know, okay, every time you use this phrase, you better put a TM on it or an R, or you better, every time you do this, you better mark it with a copyright symbol and the date. Like, so you have to start making sure that you implement those protection measures, that everyone in your business knows that, or that you are consistent in doing that as well. And then it's hard, but anytime you see infringement and you're not going to know, you're not a big company that has like web crawlers going out there to check. Like we would have literally hire third-party companies that would just go out and look for any infringement and bring back to us if it crawled anywhere on the internet and somebody mentioned something or something that was protected by IP, it would come back and alert us, and our lawyers would send out a cease and desist letter. And usually that's all it takes is a cease and desist letter. But you as a small business have to kind of do that yourself. You can't monitor the world, but if you come across some infringement, you have to take action, because your inaction could be used against you in court later that says, well, you didn't do anything with this person infringed, but now now you care when I'm infringing. Somebody could go and say, look, so and so over there is using it. And if they can prove you knew about it and didn't do anything, if you didn't know about it, you could always say, I didn't know they were infringing, but let me go take care of that. But if you knew a competitor was infringing and you didn't do anything and it came up that you were aware of it and didn't, but this competitor over here, you don't like them. So you're going to, they are infringing and you're going to go after them. So you have to be consistent. If you know about something, and like I said, just go to your lawyer, and a lot of times it's a cease and desist, or it can work something out. Some people do it. Most people aren't infringing on purpose. They do it. They just don't realize. Like before you took this webinar or this workshop, you probably thought I could use this image from the internet, and you may not have realized that that was infringing. So most times it's a cease and desist. Or if you ever get that letter, it's like, hey, I didn't know, and you can work out something with the trademark or the IP owner. Most times it can just be attribution. It can, there's things, or maybe it's a payment of some kind, or just stop using it. I mean, that might work too. So if somebody infringes on you, a cease and desist, they may contact the lawyer and say, hey, I didn't realize, and then you can work something out. So it didn't have to go to a court case every time, but most likely it's people aren't aware, and they'll stop using it once they realize that it's an issue. Two resources, the USPTO, they have really, and then US Copyright Office, they have great resources, trainings, webinars all the time if you want to learn more about intellectual property law, because it's so much fun. But if you have any questions, like I said, there's that Fair Use Index resource. They have webinars all the time about the process, especially with patents, just so you can, if you were going down that route, just for kind of, knowledge for like, what are the different things. They have great workshops. And then that is the end. Woo. So any questions? That was a lot of information. Let me stop
Nothing
sharing.
new.
Cool. You guys asked some great questions during it, so I'm totally happy with that. But I know we have like 4 minutes left, and I just want to kind of go through. So just like your next steps, make a list of just all your assets. even if you don't think they're protected or can be protected or not, at least like list them so you kind of have an inventory and then just kind of go through going, okay, which asset, if somebody were to copy it and so a competitor were to like use it, what's the impact to your business? It would it really be confusing for consumers? Um, am I going to stay local geographically or am I going to, am I selling like my like my trainings could be, I may do them online and then they could be anywhere in the US to take, so do I need more federal registration because I'm going to be doing, you know, a commerce in a wider than just, or if I'm just a local store here in Nashville and I have no plans of expansion, I may be fine with just my local protections. So last chance. No, just kidding. Again, if you haven't signed up for a mentor, highly recommend to go out to the website and check that out as a resource for your business. And that's that's all I got today.
Great, Sandy. Thank you so much. Just want to let you know that we have upcoming, excuse me, webinars. Wednesday night, there's Am I Ready to Start a Business? And this is presented by a gentleman that's owned his own businesses and very successfully. We have a new one being offered Thursday at noon, Lead with Care, the antidote to burnout culture. That would be a good one for, especially for new entrepreneurs. And then Saturday, the 8th, from 9 to noon, write your business plan. And at the end of this one, you will actually have pages of your business plan already written out. So that's also an excellent one. Be sure to go to score.org/Nashville and then click on Take a Workshop. And everything that we have scheduled right now will be on that list. And please come back and visit frequently because I'm consistently adding new ones. So it's always a surprise.
Yeah.
But let's see, we have one question here. Very good. Okay. So one last question. Should I trademark or patent my event name?
Uh, it up to you, but I would highly consider doing it. So you do have a trademark by just using, you should still use the event name. If it's an event name that you're going to kind of repeat over and over, you should definitely put the TM behind it, even if you don't federally register it. If it's an event that's going to bring in a wider audience and like maybe it's just like a local event that's only available in Nashville, like maybe you don't need to federally register it, but most events are going to be bringing, I would guess, people in, or if it's online component as well as the in-person, then and it's an event you're going to kind of repeat and want to build kind of brand and awareness around it, then I would consider federal registration.
Excellent. Thank you. And I want to thank Miriam from NBIC for being here with us on the webinar. Your support of our programs is greatly appreciated. That's all, folks, that I have. And Sandy, thank you so much for your knowledge and making it understandable to those of us that don't understand this. So,
Well, thank you, Michelle, because I can't, we instructors can't do this without Michelle. Like helps the back end and puts things on the website and keeps us all on track. So, and to monitor the comments and chat because we get rolling. And so it's always good to have that other set of eyes that are looking at and can help. So thanks to you as well, Michelle.
very welcome. Very welcome. Okay. Well, everyone, please have a great weekend.
Yeah, enjoy. Hopefully it's not going to rain. But get out there and enjoy while we can. So thank you so much for your spending your Saturday morning with us.
Absolutely. Take care, everyone. See you on Zoom.
Bye.